Hello, y'all. This is Phil Lam. I'm Vice President for the Diversity and Inclusion in Outreach. And many of you probably have known me. I've served in all different capacity. But I'm here as the chair of the President's Task Force on Racial and Social Justice. And it's a new task force which we have founded last year following a combination of events, the least of which was the killing of Mr. George Floyd. And part of the project this task force has is a speaker series, Distinguished Speakers Series. And this is a second installation, ably organized by Judge Lynne Hobbs of Superior Court, Jessica Kronstadt, who's the president of Walala, and also a board of trustee from LACBA, Ms. Kendra Thomas. And thank you very much. And I'm going to hand it off to my vice chair, Judge Lynne, to further introduce the panelists. Thank you and welcome you all speakers. And welcome for attending, Lynne. Oh, Judge, sorry.
That's all right. Thank you, Phil. I'm honored to work under your leadership and the leadership of Tammy Jensen, as well as the other members of the task force. I mean, everyone is so dedicated to its mission, and we are all constantly learning, and I look forward to its unfolding. So tonight we have a very timely and interesting installation in our Racial and Social Justice Speaker Series. It's entitled The Intricacies of a Peaceful Transition of Power, also known as a change of power, because the transition sets into action a series of events that will change the way that we all do business. So it impacts the public, including in the area of racial and social justice. All of the members of the task force have contributed to this installation, but I want to give extra recognition to Walala President Jessica Kronstadt and Attorney Kendra Thomas for the heavy lifting they have done to prepare this for us. Their eye to detail is very evident. Also, I want to extend a special thanks to Serena Scott, who as always is so helpful in doing what is necessary technology-wise. So now it is my distinct pleasure to introduce to you the panelists. The moderator for tonight's program is my friend and colleague, Serena Murillo. Then we have Justice Hoffstadt, who is an unabashed law nerd. That's what he calls himself. But when I introduce, and we have Dean Chemerinsky, but I'm going to introduce Judge Murillo first. As I said, she's the moderator, and I'm really glad that Justice Hoffstadt said that he's a law nerd, because now I don't feel bad saying that Judge Murillo is a nerd herself. She sits on the Los Angeles Superior Court and has served as a Justice Pro Tem on the California Court of Appeal. She loves teaching and lectures on issues involving gender equity, racial equality, and social justice in the context of criminal law and judicial demeanor. She was appointed by California's Chief Justice to work groups charged with examining the state's pretrial release policies. She's co-authored a published report outlining recommendations and was honored with the award for exemplary service and leadership to the judicial branch in connection with her effort. As an undergraduate, she attended Brown University and the University of California, San Diego, and has earned her law degree from Loyola Law School, which she just went back and swore in about 200 new lawyers. So good for you, Judge Murillo. I turn now to the law geek. I'm sorry, not a nerd, a geek, which is a good thing for us. Justice Hoffstadt sits on the California Court of Appeal. He actually enjoyed law school at UCLA and ended up graduating first in his class. From there, he clerked on the Ninth Circuit and then for Justice Sandra Day O'Connor. He spent the next several years in Washington, D.C., 2 of which he spent at the Justice Department's Office of Policy Development. At the turn of the century, he returned to LA, where he served as an AUSA, Assistant U.S. Attorney, for the next 6+ years. After a 3.5-year stint as a partner in the Issues and Appeals Practice Group of Jones Day, Governor Schwarzenegger appointed him to the Los Angeles Superior Court. 4 years later, Governor Brown appointed him to the Court of Appeal. In his free time, Justice Hoffstadt enjoys teaching judges, and having been a recipient of his teaching, I can tell that we enjoyed having him. He enjoys teaching also lawyers and law students. He writes books and articles about the law, and he enjoys spending time with his second grader and preschooler, even during COVID. So we're happy to have Justice Hoffstadt. I turn now to our third panelist, or our second panelist, Erwin Chemerinsky. He is the 13th Dean of Berkeley Law School. He joined the faculty as the Jesse H. Chopper Distinguished Professor of Law in 2013. But before that, he was the founding Dean and Distinguished Professor of Law and Raymond Pike Professor of First Amendment Law at the University of California, Irvine School of Law, with a joint appointment in political science. Dean Chemerinsky has been a professor at a number of prestigious universities, including Duke University, USC, and then for balance, he taught at UCLA Law School also, and DePaul. He is the author of 11 books, including leading case books and treatises about constitutional law, criminal procedure, and federal jurisdiction. He is our present day Alexander Hamilton with all of his writings, because he has now authored more than 200 law review articles and writes a regular column for the Sacramento Bee, monthly columns for the ABA Journal and the Daily Journal, as well as frequent op-eds in newspapers across the country. He frequently argues appellate cases, including in the United States Supreme Court. And in 2016, he was named a fellow of the American Academy of Arts and Sciences. In 2017, the National Jurist magazine named him the most influential person in legal education in the United States. So we are very pleased to have these panelists with us, and we are excited for you, Judge Murillo, to get started. Please do so.
All right. Thank you, Lynn, for introducing everybody so thoroughly. And thank you, everybody, for being here. It is my honor to be here with these two amazing panelists who are not only brilliant, but funny, and they really make this content accessible to everybody. So I'm looking forward to what they have to say about the questions that have been put together this evening. Before we start, a disclaimer. I have my work cut out for me because the canons of judicial ethics preclude me from asking certain questions, especially of Justice Hoffstadt, pertaining to politics, cases pending anywhere, and well, some other issues. So I have to ask him very different questions than the questions that I could ask Dean Chemerinsky, which are decidedly political, legal, and can talk about pretty much anything. So in light of that, the program is going to jump back and forth so that I don't leave anybody without answering any questions. And the second thing I wanted to tell you are the ground rules. So the chat feature is enabled. I'm going to spend a few minutes asking Justice Hoffstadt some questions, and then a few minutes with probably more than a few with both of them, Dean Chemerinsky. If you do have questions, please put them in the chat. At the end of the program, we're going to have about 15 minutes, and I think Jessica Kronstadt is going to help me, and we're going to try to get your questions answered. Okay, so without further ado, let me jump right into it. I'm going to start with Justice Hoffstadt. Good evening, Justice Hoffstadt, and thanks for being here.
Happy to be here.
So to lay the foundation for how things work at the Department of Justice, I know that you clerked for Justice Sandra Day O'Connor from 1996 to 1997, and thereafter you were hired to work in the Justice Department's Office of Policy Development in Washington, D.C., and I think that was during the Clinton administration. So my first question is, can you describe what that environment was like and speak to whether you experienced any pressure? What was the pressure like for DOJ in producing policy decisions for the White House? Can you describe that environment for us?
Sure. I'd like to just start with a prefatory comment that I'm just thrilled to be here, and it's definitely a treat and an honor for me to be on a panel with Dean Chemerinsky. So it's great to even be here. So I'm happy and thrilled to be here. To answer your question, I wanted to give a little bit more background. For those who aren't aware, the Office of Policy Development is a group, I think it's now called the Office of Legal Policy, a group of about 20 lawyers at Main Justice that operates sort of like the sister organization to the Office of Legal Counsel, where the Office of Legal Counsel, their job is to advise the White House and the Attorney General on whether things are constitutional or not. The Office of Policy Development has sort of a broader mandate to look at the policy pros and cons of legislation that's been proposed, as well as possible executive actions. While we were there, we actually had buttons made that said, just because it's constitutional doesn't mean it's a good idea, which sort of sums up what our role was at the department. I was hired in 1998 and was there until right before the 2000 election. And the Assistant Attorney General who was there at the time was a woman named Eleanor Atchison, who went by the name LD Atchison. And LD is an incredibly smart and brilliant lawyer, policymaker, and was also very well connected with the Clintons. She had been she'd been Hillary Clinton's roommate undergrad. But I remember when I was hired as part of the civil service. I went through the competitive application process, interviewed against other people, and was hired in. And when I during the interview, I sort of asked her, what is it that our mandate is going to be if I were fortunate enough to get hired? And she said, point blank, I'm not hiring you so that you can tell us what you think the White House wants to hear or what you think the Democratic thing is to do. I want you to tell me what you objectively think is the right thing to do for the American people. And then if the White House agrees or disagrees for whatever reason, that's up to them, not for what the product is that we want to give them. And I think that mandate came not only from LD, but also from the fact that the core group of people at OPD were civil servants. There were folks who had stayed on from prior administrations, from the first Bush administration, from the Reagan administration, while the folks up at the top were political appointees. The bulk of us weren't. And I found personally that having that sort of institutional knowledge was very helpful to our work. So to answer your question, I mean, I did not really experience any political pressure in coming to any policy recommendations because of the way that it was set up, which was to get us to evaluate the merits in a non-political way with the idea that the political decisions would be made elsewhere.
Okay. With regard to that, you then had to also take an oath, I assume, to uphold the Constitution of the United States. Is that right?
Yeah, that was obviously part of the mandate. I mean, usually, OLC had commented on any of that if needed, and we were sort of left with okay, even if it's constitutional, what do we do about it? I mean, the 2 years that I worked there, they were doing construction at the building, so we had to enter on the Pennsylvania Avenue side, and there was an inscription etched in stone above the doorway that said, "The place of justice is a hallowed place." And all these years later, and while I was there, I mean, it definitely sank in, and I felt that was the mandate that we had, was to try to figure out what was the just legislation in terms of public policy.
So then what would have been an appropriate response, Justice Hoffstadt, if at one time your individual policy analysis maybe did not comport with, let's say, a White House policy? How would that be resolved? How would you handle that if you did not have a boss like LD who was saying, look, I don't care about the White House. I want your independent legal analysis?
Well, I mean, I think I was I think there were 4 different levels in OPD at the time. I think I started at level 1 and went up to level 2. I wasn't at the top 2 levels that were really wrangling with the White House about what the policy outcomes were going to be. So I didn't see that personally. And the way that LD had characterized it is that, we passed to them our product up through the grapevine, and then they decided what they were going to do with it. So if that conflict was made, it was made by the policymaking presidential appointees, not by civil servants like me.
So then at the conclusion of your term there, what happens when a new president comes into the White House? Did the people that were in OPD, for instance, at the end of the Clinton administration, what happened to them when President Clinton was no longer there?
Well, the folks at the very top, LD and her deputies, all fell into what is categorized, I believe, as a Schedule C appointees. So they were they served at the pleasure of the president, and when the president's term ended, they left. The rest of us who were civil servants we had the civil service protections. We could stay if we wanted or move on. I think as a practical matter, most people moved on, but as I indicated, there were people who did not from prior administrations. So whether or not that changes is unclear at this time. I know that I believe it was in October of this past year, President Trump signed Executive Order 13957, which created a new category that was sort of carved out of the civil service called Schedule F, that applied to policymaking, policy advising, and other confidential positions. I know that from the papers, there's a lot of debate one way or the other about the merits of that proposition. And there's a lawsuit pending about whether it's a viable thing. And I don't know what, if anything, President Biden is going to do about that. So that may or may not have an effect on my personal experience, which is obviously historical and relatively anecdotal.
All right, one last question about that. So the Schedule C appointees or employees are the ones who stay, is that right?
The Schedule C are the ones who are exempted and who are not sort of the civil servants. The general rule is you're civil servants unless you're Schedule C or one of those other exceptions.
I'm sorry, I had it backwards. So the non-Schedule C civil servants, then, what was there? Is that a political appointment? I mean, you were hired under Clinton. Does that mean you had to be a Democrat, or do those people stay no matter what, and they are of varied political backgrounds?
I think that as a general rule, I mean, they don't really ask what your political affiliation was. And you generally stick around. I mean, I think obviously the Office of Policy Development is a policy advising and an analyzing organization. So it's going to be more in tune with whatever the policy priorities are of the administration. There are a lot of other parts of Main Justice, such as the litigating arms, the Civil Rights Division, the Federal Courts Division, all of those that don't that really aren't going to be as dependent on political considerations, and therefore those folks stay on a long time. So I think it depends in some respects as to which part of Main Justice you're in, as to whether or not there's administration-driven turnover.
Okay, so what I'm hearing is they'd stay regardless of who the Schedule C appointments might be, or regardless of who's in the White House, generally.
Correct.
All right, thank you very much, Justice Hoffstadt. Dean Chemerinsky, I would like to turn to you for a moment and talk about an issue that everybody's been talking about, which is impeachment. I know there's been a lot of discussion in the press regarding a couple of ways of impeaching a sitting president, and I want to talk to you a little bit about that. I know there's one aspect or one way to impeach a president, which is through a lot of discussion of the 25th Amendment, and then there's Article 2, Section 4 of the United States Constitution. Can you describe each of those processes and the implications and the differences between the two?
Sure. Let me start by saying how delighted Anna and I am to be with you and Justice Hoffstadt. The 25th Amendment is a way in which a president can be temporarily or permanently removed from the duties of office if it's deemed that the president is not capable of performing those duties. The 25th Amendment says that if the vice president and the majority of the cabinet deem the president unfit to perform the duties of the office, the president will be relieved of those duties. The vice president then assumes them. If the president believes that he is fit to perform the duties, the president then can say, I'm taking them back. The vice president of the cabinet could then say, no, you're not fit. And then it goes to Congress for resolution. This has been invoked a couple of times by presidents voluntarily when they were going through medical procedures. It's never been done involuntarily. There was a request by the House of Representatives that Vice President Mike Pence invoke the 25th Amendment. He refused to do so. And of course, it all became moot yesterday. The Constitution allows a way to permanently remove a president from office, and that's impeachment and removal. The Constitution says that the president, and for that matter, the vice president, federal judges, all office of the United States, can be impeached and removed from office for treason, bribery, or high crimes and misdemeanors. It takes a majority vote of the House of Representatives to impeach and a 2/3 vote to convict. 4 times in history, presidents have been impeached by the House. Andrew Johnson in the late 1860s, Bill Clinton in 1998, Donald Trump in January 2020, Donald Trump in January 2021. The first 3 ended in the Senate not convicting, so those presidents were able to finish their terms in office. And of course, we don't know what's going to happen with regard to the Senate and the most recent impeachment of President Trump. And it raises a question that's much debated right now. Can the Senate even try Donald Trump since he's no longer in office?
And I think that's something that Lindsey Graham has been talking about. He invokes the authority of Article 1, Section 3 of the Constitution, which suggests that there are 2 remedies essentially in a judgment once a president has been impeached. One involves removing him from office and the other depriving him of certain honors. Can you speak to that? Is that accurate? What is your opinion as to whether or not that remedy can be sought once the president is no longer in office?
Sure. Let me separate this into a couple of parts. One is, can the Senate even consider convicting Donald Trump once he's out of office? And there are arguments on both sides. There are constitutional experts on both sides. On the one hand, some say the text of the Constitution says it's the president who can be impeached and removed. If the president of the United States is being tried in the Senate, the Chief Justice presides. That therefore applies only when somebody is president. On the other hand, there's a good deal of historical evidence to suggest that impeachment and trial can occur after somebody's no longer in office. When Ulysses Grant was the president, the Secretary of War was William Belknap. Belknap was under investigation for corruption. He resigned before the House could consider impeachment. After Belknap left office, the House voted articles of impeachment and Belknap was tried in the Senate. In fact, John Adams back in 1800 spoke about the ability to impeach and convict even after somebody's left office. Impeachment comes to the United States from English law, and there are examples there of people being impeached even after they left office. So my conclusion is that there can be a trial, there can be a conviction should the Senate vote by 2/3 to convict Donald Trump. The Constitution allows separately for there to be other consequences, such as disqualification from future office. And I think that the Senate can do that as well, even though Donald Trump has left power.
But so then in your opinion, it is possible for the Senate to simply decline to hear the matter because he's no longer the president?
I think the Senate could choose to do that. The Constitution assumes that if the House impeaches, there'll be a trial in the Senate, but it doesn't require it. And I'm not sure what require would even mean here. What if the Senate simply chooses not to hold a trial? There's no one that have forced them to do so. Quite relevant to that, and also to the larger question, the Supreme Court has said that challenges to the impeachment and removal process are political questions left entirely to Congress. In 1993, in Nixon versus United States, the Supreme Court said that Congress has discretion as to how to proceed with regard to impeachments. The court shouldn't get involved. That case involved a federal judge, Walter Nixon, who was impeached by the House. It went to the Senate for a trial. The Senate formed a committee to hear the evidence against Walter Nixon and make recommendations to the whole body. Nixon objected to that procedure. He sued. He said the whole Senate should have to try him. The Supreme Court unanimously said it's left to Congress to decide impeachment and removal procedures. So if the Senate were to decide not to hold a trial, I don't think anyone would go to court and force them to do so. If the Senate decides to hold a trial, I don't think anyone would go to court and stop them from doing so.
So in that regard, what do you believe the next steps would be now that the House has issued articles of impeachment and it lies with the Senate? In your opinion, how do you think this can move forward?
I think the Senate is going to hold a trial of Donald Trump. In part, it's because the Senate is effectively controlled by Democrats with a 50-50 split and a Democratic vice president. I expect that they will go forward with the trial. But also, the now Senate Minority Leader, Mitch McConnell, has indicated that he at least favors a trial. So I don't know what the outcome is going to be, but I certainly expect there's going to be a trial.
Dean Chemerinsky, you had issued an opinion that I read that discussed the fact that you were hopeful that the House would not rush to impeach the president. Obviously, that happened anyway. What were some of your concerns with the House rushing to impeach?
Always before there was a committee to hear the evidence, it recommended articles of impeachment to the House, and they deliberated. In this instance, there was no committee to gather evidence. The House met as a whole. There was really never the opportunity to put together the record and have the full discussion. I supported the impeachment effort here, but I worry that this sets an undesirable precedent for the future. The reality here is the impeachment wasn't about removing Donald Trump from office. The impeachment occurred with us just having a week left in power. The impeachment was about sending a message. And I worry that by rushing it in this way, it sent a bad message for the future, and that there was no reason to rush it. It could have happened 2 weeks, 3 weeks later. But I understand why the House Democrats proceeded the way they did.
Thank you. Switching gears a little bit to talk about the power of a president to pardon potentially himself. Obviously, that didn't happen. But is that something that is supported by the Constitution, in your opinion?
The Constitution says that the president can grant pardons and reprieves, and it's always been thought to be a plenary power. I spent a lot of time in the last few weeks answering the question, can the president pardon himself? There's obviously no definitive answer. No president has ever tried to do so. My own conclusion is that a president can't pardon himself. I understand that that is the advice that former Attorney General Barr gave to the president, and he obviously followed it. In part, I think it's because the language of Article 2, the president can grant pardons and reprieves, implies that it's something bestowed on another. In fact, if you look at Anglo-American history, not just in the United States, pardons have always been granted to others. There aren't instances people pardoning themselves. Even more important, I think that the core of the rule of law is that no one, not even the president, is above the law. If a president could pardon himself, doesn't that then effectively put the president above the law?
Another question along those lines, Dean Chemerinsky, is the effect that a presidential pardon could have on a state prosecution. So for instance, there was a discussion, I think in the news, regarding a potential prosecution of former President Trump in New York. If he were to have given himself a presidential pardon, would that foreclose the states, for instance, New York, from following through with their prosecution?
Absolutely not. The president can pardon as to federal crimes. The president has no authority as to pardon as to state law crimes. So even if the president has pardoned people, and even if the president pardoned himself as to federal crimes, if there are state law offenses, they can still be prosecuted in state court.
Okay. One last question on the presidential pardon issue. How specific does a presidential pardon have to be? Can the president pardon people for crimes that have not yet been charged? And what is the effect of the admission that kind of lies therein if somebody is accepting kind of a vague pardon for things that haven't been charged by the federal government? I mean, how specific does the pardon have to be?
It's always been thought that the president can pardon for any federal offense, whether it's been charged or not charged. Anyone accused or convicted of a federal crime, in theory, can be pardoned. The best example of this would be Gerald Ford's pardon to Richard Nixon. Now, you ask a question for which there isn't a settled answer. How specific does the pardon have to be? The pardon that Gerald Ford issued to Richard Nixon was for all federal offenses. Is that permissible? There's certainly a strong argument that the pardon has to be much more specific as to the crimes, whether those crimes have been charged or not, whether the person's been convicted or not. I tend to believe that the pardon has to be for specific offenses, and therefore I'm troubled by the idea of a pardon for any crime that the person might have committed.
Thank you, Dean Chemerinsky. I'm going to switch back to Justice Hoffstadt for a moment and talk about some of the articles that each of you have written on various topics pertaining to current events. Justice Hoffstadt, in May of this year, you wrote an article in the Daily Journal called Reality Check. And it was interesting to me because you described the judicial branch and you said they were not, quote, humble bragging when Alexander Hamilton described the judicial branch as the weakest branch in Federalist Number 78. How powerful is the judicial branch's power and their duty to say what the law is?
I mean, I think that, you know, what Hamilton was getting at and laid out in Federalist Number 78 was the fact that the judicial branch is in many respects limited along a lot of fronts. When it comes to whether the federal courts have jurisdiction, at least statutory jurisdiction, that depends on Congress's decisions to grant jurisdiction or withdraw jurisdiction and sort of expand or contract what the courts can do as a matter of statute. Also, the Congress has the power of the purse, so it can decide whether to fund or not fund the courts. The executive is charged with enforcing the judgments. The judicial branch doesn't have its own enforcement mechanism, so is dependent upon the executive for enforcement. And the other thing that's not in 78, but is sort of, I think, widely appreciated is the fact that courts can't create their own dockets. Courts are beholden to the litigants to bring disputes to them, to cases or controversies to them. And so, you know, if the legislature decides to not give a lot of money to the courts or to narrow their jurisdiction, or if the executive decides they're not going to enforce the judgments, or if Oliver Brown decided not to bring a lawsuit with the other parents, there might have been no Brown versus Board of Education. And so in that respect, the courts are dependent upon many other parties and entities in order to be able to do what they do. And in fact, when you look at Marbury versus Madison, as we all know, I mean, all the Constitution says is the courts have judicial power. It wasn't until Marbury that Chief Justice Marshall laid out that meant that there's a power of judicial review for constitutionality. And what all of this boils down to, I think, and I think as Federalist 78 sort of enforces, is that the court's power is derived in many respects on its perceived legitimacy. And that legitimacy turns on the fact that its decisions are viewed as being a product of judgment and not of sort of will. And by that, I mean sort of mercurial, just sort of brute power and decisions. I think that's partly why judicial decisions are in writing, because courts are required to lay out what their rationale is when they're deciding things so that the public and others can evaluate whether or not what they're putting out is in fact the product of reasoned judgment. I think the degree to which legitimacy is an issue likely depends on the level of the court. I think at trial courts, the law is very settled. And there they basically, you know, many cases turn on just what the facts are. And generally fact finding is not considered to be particularly controversial. At the intermediate court of appeals levels, I think, at least from my experience, when I clerked for Judge Hall on the Ninth Circuit, I thought that 95% of the cases, the answer was fairly clear on appeal because the law was relatively settled. And because of the standards of review that are largely deferential to what the trial court finds, there wasn't a whole lot that the intermediate appellate court can do with those factual findings or those exercises of discretion. When I got to the Supreme Court and clerked for Justice O'Connor, I thought it was flipped. There were 5 or 10% of the cases where the answer was fairly clear, and the Supreme Court was taking the case to basically definitively say, no, this is what we meant. And the rest of the cases, the 95%, there really was no answer. So I think that that's why the focus is much more on the courts of last resort as to whether or not there's more of a concern about legitimacy, because there's more of an opportunity for judicial, essentially common lawmaking or interpretations of either the Constitution or legislative intent.
Well, let me flip that a little bit, because certainly in reviewing courts, the record is set by what has been brought before you, as you described, whether it's in the Supreme Court or the Ninth Circuit Court of Appeal. But when you're talking about a trial court and you have litigants coming before you, you described in your article what happens when you have some litigants who might want to present kind of an alternative reality to what the events were, or their version of the facts are so vastly different. What are some of the judicial doctrines and policies that work to make sure that the courts reject alternative realities that are sometimes proffered by lawyers and litigants?
Well, I think some of those rules that constrain attorneys from putting forth alternative realities exist in the rules of ethics. I mean, there's a duty of candor to the courts. There's a duty to present even adverse authority. There's a duty not to misrepresent. So I think that in many respects constrains just the practice of law generally. Beyond that, I think there are doctrines like the collateral estoppel doctrine, law of the case, that bind parties to what has happened before and prevent them from sort of reinventing the past. But I think even those doctrines rest on what I think is sort of the underlying power of the courts. Courts have the power to research law and to judicially notice what has gone on before in a case, as well as facts that are incontrovertible. So if a lawyer came in and said the earth is flat, a court can say, no, actually it's not flat. And we could take judicial notice of that fact. So there is more of a check on that give courts the power to say, no, we're not going to believe that. There are some boundaries beyond which litigants can't really go because the courts won't allow them to. And of course, obviously the focus on you have to present evidence. And if there's no evidence, you can't move forward at whatever stage you're trying to do so.
All right, thank you very much, Justice Hoffstadt. Dean Chemerinsky, I want to turn back to you. And Alexander Hamilton, aside from being a famous Broadway star now, I'm wondering if you agree. Do you agree with Alexander Hamilton in Federalist Number 78 that the judiciary is the weakest branch?
Yes and no. In fact, just this morning, I was teaching Marbury versus Madison and talking about Federalist Number 78. Of course, as Justice Hoffstadt said, the courts don't have the power purse or the power of the sword. The Congress gets to control the purse. The courts can't enforce their own judgments. But on the other hand, Marbury versus Madison said, it's the province and duty of the Judicial Department to say what the law is. And that's an enormously important power. Whether there's going to be a right to abortion or not is left to the Supreme Court. We can then go through the countless other issues where the court gets the last word effectively. Whether gays and lesbians will have the right to marry, that's left to the courts. Whether Richard Nixon had to turn over the Watergate tapes, well, that was effectively decided by the courts. Whether President Truman could seize the steel mills was decided by the courts. The power to interpret and decide the law is enormously important. And it's a way now that Hamilton couldn't have possibly foreseen when he wrote Federalist Number 78. So there's ways in which the court is less powerful than the executive and legislature, but since the court can declare unconstitutional what the executive and legislature does, ways in which it's more powerful.
Thank you, Dean Chemerinsky. Moving on to some of President Biden's policies and priorities. Today, there were approximately, I saw conflicting news reports. In my estimation, there were over 20 executive orders that were issued. Dean Chemerinsky, where do you see his priorities? I think some of the executive orders covered, there were approximately 10 pertaining to COVID. He covered immigration, climate change, racial and LGBTQ equality, the economy, government accountability. Where do you see his priorities leading compared to what he was left with some of these executive orders?
Let me, as a preface to answering that, talk about the power of the president to issue executive orders. Executive orders historically have been about guiding the operation of the executive branch of government. And the president, as chief executive, can say, agencies, this is how I want you to proceed or not proceed, so long as the executive order isn't violating a statute, so long as it isn't violating the Constitution. I think over recent presidencies, and this includes Republican and Democratic ones, there's been more effort to use executive orders, especially because of the difficulty of getting legislation through Congress. And there's a real difficult question that I think the courts are going to have to deal with is, where is the line drawn between what can be done by executive order and what can be done by statute? Let me give you an example. One of the executive orders that President Obama issued was the Deferred Action for Parents of Americans. And this said, if there's a non-citizen in the United States with a child who is a citizen, there won't be a deportation proceeding against the person so long as they don't have a felony conviction or serious misdemeanor conviction. Well, litigation was brought as to whether that could be done by executive order. A federal district court said no, that exceeded the president's power. The Fifth Circuit agreed 2-1, and it went to the Supreme Court in 2016, and the justices split 4-4. It was the year that Justice Scalia passed away. Well, President Biden has renewed the executive order for another program, the Deferred Action for Childhood Arrivals, the so-called DACA program. And there's a lawsuit already pending in Texas as whether the president can do that by executive order, or whether it has to be by statute. I think that's going to end up going to the Supreme Court. It's clear that President Biden was using executive orders to reverse some of the Trump policies, particularly with regard to immigration and the environment. It was also clear that he was trying to use executive orders to really push forward the fight against COVID-19. And I expect that most of these executive orders won't be challenged in court, but some are sure to be. And this underlying question, what can be done by executive order, opposed to what has to be done by statute, is going to need to get resolved.
How long has this been going on? It sounds like you're suggesting that to a certain degree, executive orders encroach a little bit on the role of the legislature, which is their duty to promulgate laws. This seems to be increasing in popularity. I mean, the flurry of executive orders that were issued today. Can you speak to that, Dean Chemerinsky?
Executive orders began with George Washington. Every president has issued them. But I do think over recent presidencies, Bush, Obama, Trump, now Biden, there's more effort to use executive orders. And I think that if it is about regulating private behavior, that has to be done by statute. If it's purely about how an executive agency is going to conduct itself, that can be done by executive order. So if President Biden wants to say to the executive agencies, you can't discriminate on the basis of sexual orientation or gender identity, and that is one of the executive orders, I think he has the prerogative to do that. But if it comes to private businesses, President Biden doesn't have the authority to tell them they can't discriminate on that basis, though Congress has, according to the Supreme Court.
Thank you, Dean Chemerinsky. Justice Hoffstadt, I'm going to switch back to you for a moment, hoping you will talk to us a little bit anecdotally about your experience as an assistant United States attorney. There has been certain situations, I think, that have been described where perhaps an assistant U.S. attorney might be handling a case and is forced to handle it in a way that maybe does not comport with the policy of the United States attorney. Was there ever a case that you handled as an AUSA where you disagreed with the policy manual or you wanted to do something different than what was outlined in the policy manual?
I mean, I can say, I mean, the quick answer to that question is no, but let me give a little bit more background on how it all worked when I was there. There's the sort of umbrella of Main Justice and the Attorney General. Within Main Justice, there's a group called the Executive Office of the United States Attorneys, or the EOUSA. And each of the U.S. attorneys around the country and all the different districts follow the United States Attorney's Manual, which sets out sort of the criterion for when people should be charged and what they should be charged with, sort of in broad principles, and what things shouldn't be considered when making charging decisions, and a array of other things. Within that structure, though, other than that, and other than the personnel policies that Main Justice requires all of the U.S. attorneys' offices to follow, by and large, each of the United States attorneys has a fair bit of discretion in setting their priorities for what types of cases they're going to devote the resources of their office to. And so I was there at the very, very tail end of the Clinton administration into the first 5 or 6 years of the Bush administration. So there was a changeover in U.S. attorney. I did not notice any, any sort of sense of, I mean, no one at any point said, no, that's, this is not the type of case we're doing anymore. Part of that may have been a function of the fact I was relatively young in the office. And so I wasn't doing the high profile cases that anyone particularly would be all that concerned about for those purposes. But even as I moved up in the office, the way that it was structured is we had indictment committees that we would present our cases to other AUSAs and for feedback and for approval. And generally, we did not, we would get suggestions and whatnot, but we did not get countermanded, and we were allowed to exercise our discretion. Again, it was important to exercise it in a fair and just way, but I did not personally experience sort of ever getting countermanded in that way, because it was sort of the ability to have discretion within the confines of the U.S. Attorney's Manual was sort of built into the system.
So is there a circumstance that you can describe? I understand that you've never felt pressure to kind of deviate from the policy, but was there ever a circumstance where you were allowed to exercise your discretion in a way that you thought was fair, that maybe didn't exactly comport with the policy manual, but you were supported nonetheless?
Well, I wouldn't say that it didn't support, it wasn't completely supported by the manual, but I had one case that I was prosecuting an individual. The grand jury had returned an indictment. He'd committed a sort of investor fraud. I think obtained $3-4 million from various investors, and then gone on to commit money laundering to launder the proceeds, and as part of that committed bankruptcy fraud and tax fraud and several other types of related cases. After the grand jury returned a superseding indictment, he went into pretrial services to check in, as he was required to do, in the courthouse, and then went to the men's room and ingested a cyanide tablet and killed himself. This was, of course, incredibly devastating news. I mean, I brought the case because I thought that it was an appropriate case to bring, that was justified by the evidence. And under the mandatory sentencing guidelines, he was looking at a handful of years in federal prison. It was obviously not a capital crime. And so that was very distressing. The case agents that I worked with after that had suggested, perhaps focusing and bringing an investigation against his wife for her involvement in the case. And I ultimately decided that that was not appropriate, that any liability, criminal liability she might have, if at all, would have been minimal, and that in light of the circumstances, it simply wouldn't have been just. And so I was able to exercise my discretion to say, we're not going to proceed, this case is closed. And so I don't believe that that was necessarily in violation in any sense at all of the attorney's manual, but it gives you some sense of the discretion that prosecutors have in trying to do what they believe to be the right thing.
Well, especially because I think you suggested earlier that, or maybe I got it from somewhere, at the time, the policy manual indicated once a decision to prosecute has been made, the attorney for the government should charge and pursue the most serious, readily provable offenses. By definition, the most serious offenses are those that carry the most substantial guideline sentence, including mandatory minimum sentences. So it sounds like you were able to exercise your discretion to not go for the maximum sentence against somebody who may have been an aider and abetter, based on the circumstances of her husband's death. I mean, isn't that kind of an example of you being able to exercise your discretion despite what is stated in the policy manual?
Well, the manual, on some level, I mean, I think that's right. If you had made the decision to charge, this is sort of the precursor decision about whether to charge and whether to investigate. So the manual breaks it up into little pieces like that. But I think that the manual makes clear when it sets out its principles of prosecution as to what you should look to. And it does allow for consideration of the individual circumstances in a particular case. And so I think that it does grant that very broad discretion.
Thank you. One of the questions, Dean Chemerinsky, that was proposed by the committee, and I do have to say that as a judge, I'm not suggesting that anybody should or should not be prosecuted, and I have no opinion about this whatsoever, but there was a question from the group as to whether former President Trump should be prosecuted, in your opinion, or how may he be prosecuted, if at all. Can you speak to that, Dean Chemerinsky?
Sure. I think there are many crimes that Donald Trump can be investigated for and potentially prosecuted for. I know of no constitutional or legal limit on prosecuting a former president. There is a difference of opinion as to whether a sitting president can be indicted and prosecuted. There is an Office of Legal Counsel memo in the Justice Department from 1973 that says that a sitting president can't be indicted. Others, constitutional scholars, believe that sitting president can be indicted and prosecuted. But that's now academic with regard to Donald Trump. Donald Trump is no longer president. I know of no limit on the ability to prosecute him. It's possible that some of the things he might be investigated and prosecuted for have nothing to do with his conduct as president. I know that there's a grand jury in New York that's investigating things related to Trump's businesses. I think there's a real question of whether or not Trump can be indicted, be prosecuted for incitement of violence and incitement of insurrection for the events that occurred on Wednesday, January 6th. The legal test for incitement from Brandenburg versus Ohio in 1969 is that incitement occurs if the speech has a likelihood of causing imminent illegal activity, and if the speech is directed at causing imminent illegal activity. Donald Trump in that speech 20 times used the word fight. Standing next to him, Rudy Giuliani said, we need to have trial by combat. I think there's an argument there that there was a likelihood of imminent illegal activity, given everything that preceded the rally and the nature of the rally. And I think you can say using the word fight 20 times and trial by combat is directed at causing imminent illegal activity. And I'll be very interested to see whether the US attorney in DC decides to indict Trump and Giuliani for this. I know that there will be an impulse on the part of the Biden administration to be reluctant to indict and prosecute a former president. That's not something that's occurred previously. Biden wants to be healing, and it would be divisive. On the other hand, as I said earlier, the core of the rule of law is that no one, not even the president, is above the law.
So the rule that a sitting president cannot be prosecuted doesn't serve to shield him from future liability for any crimes that may have been committed while he was a sitting president. Is that correct?
That's correct. Well, again, no one knows this for sure. The only time it might have arisen was Richard Nixon and Gerald Ford issued a pardon. The Justice Department memo and those who believe that a sitting president can't be indicted and prosecuted say it would too interfere with the president's ability to perform his or her duties in office. And so we shouldn't let a sitting president be indicted, because then whoever's prosecuting the president can interfere with the workings of government. That has no relevance after the person has left office. And so the reasoning that shields a sitting president wouldn't apply to a former president. But even as to a sitting president, there's strong disagreements as to whether or not such a person can be indicted and prosecuted.
And I have a similar question. The DC metro area is unique. Is that considered to be a federal prosecution, a state prosecution? What is that prosecution that could emanate from that region?
DC is part of the federal government. And so remember earlier in this conversation, we were talking about how a pardon precludes federal prosecutions, but not state prosecutions. There is no analog to a state with regard to DC. There is a DC set of courts as well as the federal courts in DC, but they're all part of the federal government.
All right, thank you, Dean Chemerinsky. Justice Hoffstadt, back to you for a moment about how the judicial branch might be able to protect its integrity from misinformation, as even evidenced by the limitations of some of the questions that I can ask you or that I can even ask myself. What are some of the ways that the judicial branch can protect its integrity from misinformation, since it is so constrained in what it can say and do?
I mean, by misinformation, I mean, on some level, if you're referring to sort of how it can protect itself from misinformation presented by the litigants, I sort of touched on that earlier with, you know, the doctrine of judicial notice and estoppel and law of the case that can sort of prevent that type of information from being, or at least they have the tools to sort of see through that information and get at the truth. Is there a further implication to that question?
Perhaps how the judicial decisions are interpreted and what is the word that I'm looking for? Published or reported or repeated to the American people regarding what a judicial decision actually is or what it stands for. I mean, some of these decisions are not super accessible. I think we can agree on that to the general public. Do you think that that's something, I mean, do you think the judicial branch should be able to do something about simplifying those or making them more clear to the public at large so that they understand the implications? I mean, as Dean Chemerinsky mentioned, some of these major social justice cases that have come down throughout history are now listened to, let's say on oya.com or something like that. Do you think that there's a way that judicial decisions can be communicated to the public at large so that they can protect themselves from misinformation?
I mean, I think that, you know, transparency and getting the results of what the courts are doing, and even their you know, the input that the court has in terms of the briefs and the arguments, having those be publicly accessible, I think is critically important to the general public understanding what it is that courts do that can feed into their legitimacy. I think that there's been a long push, and obviously Dean Chemerinsky can speak to this on a far more personal basis than I, about the Supreme Court making its arguments accessible. And the fact that we have COVID now, I mean, now they were doing live stream, at least audio. Whether that will continue afterwards or whether or not we might get some easing of the prior restrictions where they would only release a transcript afterwards or a tape afterwards remains to be seen. But I think that I know that a lot of local courts, the California Supreme Court, now most of the courts of appeal in California are all live streaming their arguments so that it is more accessible to the courts. I think that opinions, they're generally accessible now on the internet, at least for some period of time, in a way that they weren't before. So I think that we are getting more information. Part of it may be just the sort of what the media chooses to focus on in terms of having even a broader amplifier about what it is that's going on. I mean, I think the Supreme Court gets a lot of media attention, as it should, but the lower courts obviously get a lot less. So to the extent that people are trying to figure out, what the Second District Court of Appeal is doing in LA, it's going to be a little bit harder of a gap to fill.
Thank you, Justice Hoffstadt. I'm getting some information that I think the group wants me to address some of the questions that are being stated in the chat. So one of them pertains to something we just talked about. So this might be a good time to read one of these questions. One of the people watching wants to know if Dean Chemerinsky can please discuss more particulars about a Senate trial for impeachment after the president has left office.
Well, remember, it's never happened, so it's hard to know much in terms of particulars. There have been 3 Senate trials of presidents before: Andrew Johnson, Bill Clinton, and Donald Trump. This is going to be different because it's not about whether to remove the president from office. It's much more about whether the senators want to make a statement condemning Trump's behavior, and also whether or not they want to disqualify him from holding future office. I assume that there will be a trial. I assume that the Chief Justice will preside over the trial. I assume it will proceed as the other trials have, where there will be House managers who will present and be the prosecutors, and President Trump will have lawyers there to defend him. But when this will take place, how long it will last, none of us can know at this point.
Thank you. One of the other questions asked whether there first has to be legislation passed before it says section 3. I think they meant of the article. No, I'm confused. Section 3 of the 14th Amendment can be invoked to bar Trump from office.
Again, this is a question for which there is no clear or settled answer. Section 3 of the 14th Amendment says, if somebody has taken an oath to uphold the Constitution as part of occupying a public office, and they then engage in insurrection, they're disqualified from ever holding federal office again. So if Donald Trump is deemed to have engaged in incited insurrection, by Section 3 of the 14th Amendment, he would be disqualified from holding federal office. But Section 3 of the 14th Amendment doesn't tell us who determines whether somebody's engaged in insurrection or how they're determined this. I think there's an argument that the House impeachment resolution passed 10 days ago that deemed that President Trump incited insurrection would be enough to trigger Section 3 of the 14th Amendment. Others might say it would take conviction by the Senate to do that. The only way I see this being litigated is if Trump were to choose to run for president in 2024, somebody could go to court in some state to keep him off the ballot by trying to say that he has engaged in insurrection and under Section 3 of the 14th Amendment is disqualified. Keep in mind, Section 3 of the 14th Amendment was meant to keep those who had participated in the Civil War on behalf of the rebel states from holding federal office if they had previously taken oaths to uphold the United States Constitution. It was used by Congress to expel certain members at that time. We've never had a situation before where there's been a claim that a president engaged in inciting insurrection.
Along those lines, Dean Chemerinsky, inciting an insurrection within the meaning of Article 2, Section 4, which you previously described as allowing for impeachment if the president is charged with treason, bribery, or high crimes and misdemeanors. Where would incitement of an insurrection fall within those three grounds?
It would fit under high crimes and misdemeanors. High crimes and misdemeanors includes crimes, but it's not limited to crimes. There's a great wealth of evidence that says high crimes and misdemeanors was meant also to include an abuse of power. Now, for the House to impeach, for the Senate to convict, doesn't require that there be proof of a crime, let alone beyond a reasonable doubt. I think it's completely appropriate for the House to impeach if it finds a serious abuse of power, even if it's not criminal. But to answer your specific question, incitement, violence, incitement of insurrection is a federal crime, so it would be part of high crimes and misdemeanors.
Thank you, Dean Chemerinsky. There's another question from somebody in attendance that wants to ask, if not already mentioned, and I think we may have touched on this a bit, but the question is a little bit different. Is there any limit to a non-disclosed pardon, such as a self-pardon or one to a family member? If there is a publication requirement, do you have any sense of what constitutes publication?
I want to separate that into two parts. One part is, can the president pardon self or family members? I think it's clear the president can pardon family members. The president can issue pardons to anybody. Whether the president can pardon himself is a very different question. I've expressed my opinion on that. The president has to announce the pardons. I mean, it would be an interesting question. Could there be such a thing as a secret pardon where the president issues a pardon but doesn't tell anybody? Obviously, if it's happened before, it was kept secret, so we don't know about it. But President Trump announced a large number of pardons in the last few days. There's no indication that there were secret pardons.
Thank you. I'm going to ask one more question along these lines, and then we're going to switch to the Supreme Court. So if you're watching and you have some additional questions, either about impeachment or pardoning or the role of the courts, please feel free to add them. Like I mentioned, the last 15 minutes, we will go through those questions. I threw those in now because they seem to kind of correlate with what the moderator or the panelists were speaking about. But if you do have more questions, please feel free to add them now. The last question along these lines, Dean Chemerinsky, is we talked about the priorities of the Biden administration and some of the policies that were exhibited by the executive orders that were issued today. Are there any of the policies that the Trump administration promulgated that you believe the Biden administration might continue from a policy or procedural point of view?
I'm sure there are some policies of the Trump administration that might be continued. I don't have examples in mind. Certainly in the areas of environment, immigration, and civil rights, the Biden administration is diametrically different as it's possible to be. The attitudes with regard to immigration, including DACA, the border wall, the Biden is already repudiated. With regard to the environment, the Trump policies of promoting the development of fossil fuels, Biden is already repudiated. With regard to civil rights, such as rights based on sexual orientation and gender identity, the Biden administration is already repudiated. And in those areas, I don't see continuation of the Trump policies.
Thank you, Dean Chemerinsky. I see there's a couple more questions. I think I'm going to hold those off until the last 15 minutes. So that'll be in about 10 minutes. And then Jessica, I don't know if you want to jump in at that time and ask the panelists some of the questions that are in the chat feature.
I'm happy to do that. Thank you. Yes, I will.
Thank you. So with our last few minutes, I want to talk about some of the questions regarding the Supreme Court and the new Supreme Court justices. Dean Chemerinsky, you wrote an article for the ABA Journal regarding the Supreme Court's term in 2020, and you indicated that it was a term like no other. What inferences can be drawn from the low number of cases that the court heard last year in comparison to other years?
The court last term decided 53 cases after briefing and oral argument with signed opinions. That's the fewest number since 1862, early in the Civil War. In part, this is because there were 10 cases that were scheduled to be heard that got put off to this past October. But even if the court had heard and decided all of those, it still would have been only 63 decisions, a very small number. As recently as the late 1980s, the Supreme Court was averaging 160 cases a year. Now the Supreme Court is generally deciding most in the high 60s, low 70s, but 100 cases a year fewer. When the decrease began while William Rehnquist was Chief Justice in his last term as chief, October term 2004, the court decided 85 cases with signed opinions after briefing and oral argument. When John Roberts went before the Senate Judiciary Committee for his confirmation hearings, he was asked about this low number. He lamented it. He said the court should decide at least 100 cases a year. Roberts became chief and has never gotten to 85 cases again. We could certainly speculate as to why this is, but it means for lawyers, it's much harder to get a cert petition granted. Major issues go much longer time before being resolved.
And what is the speculation as to why that is?
There's many different likely causes. One possibility is Congress in 1988 decreased the mandatory jurisdiction of the Supreme Court. So there's fewer cases where the Supreme Court is obligated to hear it. Also, and I've heard some justices speculate as this, the development of the cert pool. It used to be that every justice would have his or her clerks read all of the cert petitions. But the cert pool is such that now I think all but 2 justices participate in the cert pool, where you'll have one clerk write a memo to all of the chambers participating in the cert pool. So instead of having 9 clerks read the memo, the cert petition, it'd be 3 clerks. And for a time, it was only 2 clerks. And some believe that that decreases the likelihood of cert grants and accounts for the smaller docket. I also think there's a lot of strategic voting that's gone on in recent years. And I think I can give examples where justices being unsure whether they've got a 5th vote decide to stay away from the issue. And that leads to a smaller docket.
Thank you. One question we have from somebody watching about the Chief Justice is whether or not the Chief Justice would have the same role, or what is your view of the role of the Chief Justice in an impeachment trial? Does it need to be as limited as the Chief Justice determined for the first Trump impeachment?
When Bill Clinton was impeached, Chief Justice William Rehnquist presided. And he said later, he did very little, but did it well. I think Chief Justice Roberts would say the same thing about the impeachment trial in January of 2020. He didn't do very much. He did it well. At one point, he admonished the lawyers to be more civil with one another. I expect that if there is, and I think there will be, a new impeachment trial of Trump, Chief Justice Roberts will preside, and he'll play the same role that he did last January.
Thank you, Dean Chemerinsky. Justice Hoffstadt, do you agree that the Supreme Court's term in 2020 was one like no other?
I mean, I agree with Dean Chemerinsky. Obviously, the lower docket was, I think, in some respects consistent with the prior trend, and lower just because of the fact that cases got moved. When I clerked in the mid 90s, I think the court was handling in the high 70s, low 80s in terms of the number of cases where they granted review. Justice O'Connor participated in the cert pool at that time, so I was one of those clerks, writing the cert pool memos. I believe Justice Stevens at the time was the only justice who was independently evaluating the cert memos. And I've heard obviously the same sorts of reasons that Dean Chemerinsky has outlined as to why there has been a decrease in the docket. But I also echo his agreement that it makes it much more difficult. I think the court waits longer for splits to ripen and deepen before they intervene.
Thank you. This will be my last Supreme Court question, and then I'm getting information that there are more questions about impeachment. So I'm going to turn that over to Jessica in just a moment. The last question that I have might be kind of a controversial one. So Justice Hoffstadt, if you don't feel comfortable answering, please don't. There has been a discussion about whether Congress can add more than 9 justices to the Supreme Court. What is the constitutional authority for adding, or for the number of justices that we have? And what are the pros and cons of such a move?
Whether Congress can do this is not in dispute, and that's not controversial. Whether Congress should do this is very much in dispute and is controversial. So let me start with the former. The Constitution does not specify the number of justices. The number of justices is set by statute. Over the course of American history, it's varied between 5 and 10. At the beginning of American history, there were 5 justices, and each was assigned one territory to also be the Court of Appeals judge. And this was called, there would ride circuit there. And ever since, those have been called the Circuit Courts of Appeals. And as the United States grew, another justice was added for the new territory until by the 1860s, it got up to 10 justices. Hard for us to believe now that there was a choice to have an even number of justices. In the late 1860s, there was a terribly unpopular president, Andrew Johnson. He had been impeached. Congress didn't want him to pick a Supreme Court justice. So Congress said the next time there's a vacancy on the Supreme Court, that seat will be eliminated. And it became 9. And it's been 9 ever since. But 9 is really a historic accident. Congress, by statute, assuming the president signs the bill, or Congress overriding the president's veto, can increase the number of justices to whatever number they deem appropriate. There's no constitutional limit on it. The Constitution is silent. Now the controversial question, should Congress do this? Let me try as fairly as I can to answer your question about pros and cons. On the one hand, those who favor it would say that the Republicans in recent years have engaged in court packing. The way they blocked Chief Judge Merrick Garland from being considered, the way they rushed Amy Coney Barrett's confirmation really is court packing. Those who favor this say, look at the ages of the conservative justices. Amy Coney Barrett is 48 years old. If she stays on the court until she's 87, the age was just Ginsburg died, she'll be a justice into the year 2059. Neil Gorsuch is 53, Brett Kavanaugh is 55. Next week, John Roberts will turn 66. Sam Alito is 70. Clarence Thomas is 72. Progressives would say that unless the size of the Supreme Court is increased, we're going to have a very conservative Supreme Court for a long time to come. The cons. Well, those who oppose this would say, if the Democrats increase it to say 11 or 13, the next time there's a Republican president, they can increase to 15 or 17. There would be no stopping point. And besides, they would say, this is court packing, and changing the size of the Supreme Court to affect the outcome of cases is undesirable. When President Roosevelt proposed this in 1936, it was rejected, and it should be rejected now. Those are the arguments on both sides.
Thank you. Justice Hoffstadt, anything you want to add to that?
No, I think I'll stay away from that one.
All right, thank you. There are more questions I could ask you about the Supreme Court, but I think people want to hear a little bit more about impeachment. So Jessica, did you want to address some of the other questions that are being asked?
Sure. Thank you. Thank you, Judge Murillo. Thank you, Dean Chemerinsky, and thank you, Justice Hoffstadt. Dean Chemerinsky, one of the questions we have from the audience is, must the procedure regarding remedies for impeachment for disqualification from future office follow an actual conviction, or is that impeachment or disqualification process a freestanding remedy?
We don't know. Always before, when there was conviction, either the Senate also passed a disqualification resolution, or sometimes the Senate did not pass a disqualification resolution. I mean, speaking here of when there's impeachment of federal judges and conviction then of them, that's really where the impeachment have led to convictions before. There's an argument that says that the Senate could disqualify without having to convict, but there's not precedent for that before. The precedent is in some prior instance of convictions, there was also disqualification.
Thank you. Are there legal grounds and or precedent to hold the senators who voted against approving the Electoral College votes in violation of their oath to uphold the Constitution and possibly remove them from office?
In theory, the Senate could choose to expel them. The House and the Senate have that ability to expel members. In reality, I think it's highly unlikely that that would happen.
Another question, if you're willing to opine, Dean Chemerinsky, what is your opinion on whether or not President Biden should pack the Supreme Court?
I'm glad to opine, and I said this, I would favor expanding the size of the Supreme Court because I do believe that there was court packing by the Republicans, and because otherwise it's not just going to be a conservative Supreme Court, but a very conservative Supreme Court for a long time to come. However, I don't think it's realistic or possible right now. If there were such a bill, even if you could get it through the House, I have no doubt that the Republicans would filibuster it in the Senate. And it would then take the Democrats eliminating the filibuster for legislation. And already some Democratic senators said they don't want to eliminate the filibuster. So I just don't see a way it would be able to get through the Senate.
There's another question which relates back a bit to the pardons, which is that it was speculated that Trump issued pardons for himself and his children, and that those pardons would not be disclosed unless either Trump or his children are actually charged. Is that a possibility?
I guess it's a possibility. We don't know what we don't know. If there is a secret pardon, we don't know of it. And yet, it's hard to imagine if there was a secret pardon that somebody wouldn't have leaked its existence. And the tradition is that pardons aren't secret. That's why the long list of pardons, even very controversial ones, have been announced over the last few days.
Thank you, Dean Chemerinsky, and thank you, Judge Murillo and Justice Hoffstadt. I'm monitoring both the chat and the Q&A, and there, at least at this time, is no more. If anyone has maybe a last minute question, now is your opportunity to ask this distinguished group of people.
I have a question for Justice Hoffstadt while maybe people are formulating some more questions. So I'm curious, having clerked for Justice Sandra Day O'Connor, tell us about how well do the clerks get along? Do they have much interaction? Do you guys get in arguments and fights over certain opinions? What's it like?
You mean, but the clerks of different chambers?
Yes.
Yeah, I mean, I've heard tale of cabals of clerks who get together and shoving matches in the courtyard with people ending up in the fountains. We had a fairly boring year, I think. I mean, I was there the same year as Senator Ted Cruz. He was clerking for Chief Justice Rehnquist the year I was in Justice O'Connor's chambers. But
no fight broke out? You didn't know, nothing on the knuckles, nothing in outside the courthouse?
No, there was nothing like that. In fact, the year that I was there, the clerks made a concerted effort to be collegial and get along. The tradition was every Thursday night, one chambers was responsible for hosting a happy hour, and we would cycle through 10 because there were 3 justices who had retired, and each had one law clerk assigned to their chamber. So there were the 9 sitting justices and the 10th sort of retired justices, clerks' chambers that would, put out food or anything else and do that every couple of times. We prided ourselves in Justice O'Connor's chambers at having the best food. We had like a Texas cookout in one of the courtyards, and we also had an Italian feast one night. So everyone seemed to get along very well. So I can't speak to whether or not there were people in different terms came to fisticuffs, but we never got anywhere near there.
What if your justice, what if you knew your justice was going to dissent in somebody else's majority opinion? Is it taboo for you to talk to maybe the clerks in those chambers about that? Or is that just not something you would do?
I mean, we didn't do that. I mean, we would sometimes talk sort of where people's justices were leaning and whatnot. But I mean, for the most part, the justices, the year I was there, communicated by memo as to what they were going to do. And so there was not back channel discussions. But again, I can only speak to sort of what we did.
Thank you. It looks like there's a couple more questions. People came up with some questions. Do you want to ask those, Jessica?
Sure. To Dean Chemerinsky, can a quote secret pardon be analogized to the undelivered commission in Marbury versus Madison?
Maybe. I mean, we just don't know. You know, in terms of Marbury versus Madison, John Marshall said that in order for a commission to be valid, it only had to be signed and sealed. It didn't have to be delivered. There is an argument that says signed, sealed, and delivered is really the requirement of property law. Does a pardon, in order to be valid, have to be public? So far as I know, that's how it's always been done before, but I don't know of any law, though there may be one that requires that.
This is a question I'll pose first to Dean Chemerinsky, but Justice Hoffstadt, if you feel comfortable answering, please do. Do you think that the replacement of Justice Scalia with Justice Kavanaugh would lead to a more conservative bench than it would have been had Justice Scalia continued?
Justice Scalia was replaced by Justice Gorsuch. I think that Justice Gorsuch is in some ways more conservative than Justice Scalia, in some ways maybe a bit less than Justice Scalia. The more conservatives, we've got to remember that in the area of criminal procedure, Justice Scalia was often a leader in favor of rights of criminal defendants. I don't want to overstate that, but I can give examples. In the area of the Confrontation Clause, Crawford versus Washington was an opinion by Justice Scalia, and it expanded rights for criminal defendants. The Apprendi line of cases expanding the rights under the Sixth Amendment to trial by jury and reasonable doubt, Scalia was in the majority. Towards the end of his career, there's some instances where Scalia was in dissent with the liberal justices in criminal procedure cases. In Maryland versus King, that involved taking DNA from a suspect to investigate a different crime, Scalia dissented along with Ginsburg, Sotomayor, and Kagan. In a case coming from California, People versus Navarrete, about whether an anonymous tip is a basis for pulling over a driver, Scalia dissented with Ginsburg, Sotomayor, and Kagan. I don't see any indication in the criminal area that Justice Gorsuch is going to be where Justice Scalia was. That said, last term, Justice Gorsuch wrote the opinion in Bostock versus Clayton County that said that Title VII prohibits employment discrimination based on sexual orientation or gender identity. There was never an instance where Justice Scalia cast a vote, whether it's statutory or constitutional, in favor of gay and lesbian rights.
Justice Hoffstadt, I'm not sure if you're comfortable or willing to give an opinion as to that as well.
No, I mean, I have not, I am confident I have not studied this nearly as thoroughly or as well as Dean Chemerinsky. I mean, I'll note that, at least there's one, I don't recall whether it was a concurrence or a dissent, where Justice Gorsuch, in a Fourth Amendment case, sort of propounded his sort of tentative views about where he thinks the Fourth Amendment might go, at least in I think it was Carpenter, where he was, sort of suggesting that the court might need to take a new approach without necessarily proposing what that approach might be. So at least in that area, which is sort of where I tend to dabble a lot in my writing and thinking, it's not clear where Gorsuch is going to be vis-a-vis Scalia, but other than he's taking at least approach and thinking out loud in a way that others have also sort of, I think, again, the digital versus non-digital Fourth Amendment area is an area where the court is, I think, continuing to figure out what they want to do, and I think it's going to take another couple of decades for that to get sorted out, if even then.
This is a question for both of you, which is that law firms that have represented Trump and other controversial clients have faced significant social media attacks and backlash recently. So putting aside lawyers whom perhaps each of you would perhaps think that are engaged in frivolous lawsuits, do you have a view of the propriety of such a backlash for lawyers who are representing perhaps unpopular clients?
I have a hard time with the premise that you set out, excluding frivolous lawsuits, because I believe that the lawsuits that were filed on behalf of Donald Trump challenging the results of elections were frivolous lawsuits. And so I'm not sure I can separate talking about what happened to those law firms from what they did. I'm always very troubled in blaming lawyers and holding them responsible for their clients' behavior. I was very upset about a couple of years ago when a Harvard professor was removed from a position because he represented Harvey Weinstein. Harvey Weinstein has a right to a defense. I want lawyers to represent unpopular defendants, and we shouldn't discourage that. On the other hand, what I always tell my students is everyone has a right to a lawyer, but no one has the right to your time unless there's nobody else to represent that individual. And I think we are responsible for the choices we make as to who we're going to represent.
Jessica, can I ask one of the questions in here regarding
Please.
kind of those lines?
Yes.
Justice Hoffstadt, I know you're going to want to stay away from this one. How will the Senate trial for impeachment be impeded if former President Trump lacks competent legal counsel? And how do you think that he would fare if he were to go pro se?
I think President Trump will have competent legal counsel. Harvard Law professor Alan Dershowitz, I think, has publicly said he would be willing to represent President Trump. And Professor Dershowitz is a very competent lawyer. I think there are other lawyers who would take on representing President Trump. I see no chance that President Trump would appear pro se as a lawyer.
Thank you.
I think we have, well, let's see what we can get to. But this is it's a question posed to Dean Chemerinsky, but Justice Hoffstadt, I'm curious to hear your thoughts on this too, as to what cases you'll be paying particular attention to between now and June.
Sure, let me mention just a few. One is a case called California versus Texas, which involves whether the Patient Protection Affordable Care Act is unconstitutional. One is a case called Fulton versus City of Philadelphia, and it involves whether or not Catholic social services can be denied the ability to contract with the City of Philadelphia if it won't place foster children with gay and lesbian families. There's a couple of cases involving personal jurisdiction, Ford Motor Company versus Bandemere and Ford Motor Company versus Montana 8th Judicial District, and they involve whether Ford can be sued when somebody purchased a used car out of state, brought it home, and then was injured by the car. The Supreme Court has narrowed personal jurisdiction in recent years. Will they continue to further narrow it? Those are just a few examples.
I don't have, I haven't been following the individual cases super closely. I mean, what I'm sort of looking forward to when the dust settles at the end of this term is seeing if there's any pattern at all, sort of how this new Supreme Court starts to sort out in terms of, are there lots of 6-3s, 5-4s, where where we will begin to see Justice Barrett and Justice Gorsuch and Justice Kavanaugh, and where they start to land, and if there's any sort of settling that happens now that they're all together. I think that will be interesting to study, sort of in the more aggregate fashion rather than with the individual cases.
Justice Hoffstadt, in his article in the ABA Journal, Dean Chemerinsky mentioned that this 2020 could be referred to as the John Roberts Court, and that Chief Justice Roberts has become the ideological middle. Do you agree?
Are you asking me this question?
Yes.
Oh, I mean, again, this is me just as a student of the law, as opposed to someone who has any actual opinion that has any bearing on anything other than what I happen to think. I mean, I think that's what we've seen, at least in some of the decisions, that he appears to be sort of the institutionalist on some level. And I know Dean Chemerinsky may have a different view and may see it, and his view, I'm sure, is far more informed than mine on this point. But what will be interesting is to see whether or not any of the other new justices start to take on that role as well, or whether they don't. I mean, and that's why I think, like, in the next few years, seeing where people start to land, if they land in any particular place, is going to be very interesting, because it's been such a high turnover of personnel in the last several years.
Thank you.
And I think we have time for just one more question. This is for you, Dean Chemerinsky, that Professor Eastman, someone that you've debated at times, appeared and spoke at the, we're going to call it the insurrection on January 6th, that 160 plus faculty members at Chapman demanded his firing, and he later resigned from his professorship. And the question is your opinion on any part of that, if you were willing to give it.
I would condemn what John Eastman said at the rally on January 6th. I think it was part of an incitement to insurrection. I would criticize some of the lawsuits that John Eastman filed including one on behalf of Texas, trying to get the election overturned. I find it a very difficult question as a dean when a faculty member engages in speech, because I believe in academic freedom. And yet I also believe that there's limits to free speech. And if it crosses the line to incitement, then it's not protected by the First Amendment. Thankfully, John Eastman wasn't a member of my faculty, and I didn't have to face those questions.
I'm going to turn it back to Judge Murillo. For those of you, there were a couple more questions that touched on Section 3 of the 14th Amendment. That was addressed earlier in this discussion and is being recorded. So please look at it again to get your questions answered. And with that, I'm going to turn it back to Judge Murillo. And thank you again, Dean Chemerinsky and Justice Hoffstadt and Judge Murillo for this incredible panel this evening.
Thank you. And there is one last question. Dean Chemerinsky, somebody wants to know if you would accept a judicial nomination if it was offered.
I'm
assuming that means on the Supreme Court, but
I have, well, I'm 67 years old. No one's going to be offering me a judicial nomination. And thankfully, I love my job, and so I'm not looking for anything else.
thank you. I want to thank both of you for your candor, for really breaking down this topic and being willing to answer some of the hard questions. Justice Hoffstadt, for sharing your background and the anecdotes that really help inform our understanding of how this transition of power is supposed to or has traditionally gone, and how it compares to what's happening currently. So thank you both very much. And I think that will conclude our program. I don't see that there are any other unanswered questions. Am I incorrect about that, Judge Hobbs or Judge Jessica Kronstadt? Sorry.
I think everything has been answered, and I just thank you again to all of you, and thank you, Judge Hobbs, and thank you, Serena and Kendra. It's been an honor to work with all of you.
All right, that'll do it. Thank you, everybody, for
Thanks,
joining
everyone.
in, and have a wonderful evening. Thank you so much.
Thank you so much for having me. And just us, it's such a pleasure to do this together.
Thank you. Feel the same.
Pleasure to work with both of you. Good luck. Happy
Thank
New
you.
Year.
Bye-bye.
Bye-bye.